Good morning. We are required to inform you that this webinar will be recorded and will be made available on our website later today. With that, Attorney Mark Ventoler will now begin the presentation. Thank you.
Good morning, everyone. Thank you for joining us once again. This is a first part of a two-part series on employment law topics that we're looking at in connection with reopening the workforce. I want to start by just giving you a quick overview of what we are going to cover today, and also introduce my partner, Jim Reedy, who is going to join me for the production today. Our agenda will be to take a quick review of the Families First Coronavirus Relief Act and see what kind of questions have come in during the first month. We're also going to talk about some of the wage and hour questions that we've been seeing in connection with this economic downturn. Furloughs, layoffs, and workforce reductions have been a big part of what we as employment attorneys have been seeing, hearing, and looking at. And we also want to speak about unemployment issues as the economy reopens. One of the purposes of this seminar is to address questions that the audience has. We are going to try to review some of the questions we've been seeing on a repetitive basis over the last 6 or 7 weeks, but we are encouraging you to please ask questions. We're going to try to leave some time at the end of the webinar today to answer questions that come in. Most of you now, I think we all now are familiar with how to use Zoom, but just in case you're not, there is a question and answer button somewhere on your screen, depending on what kind of device you're using. So please submit questions and we will do our best to get to them. So with that, let me also say, as I guess my lawyer has told me to say, that we're trying to provide some general guidance, but this is not intended to be legal advice. It's not a substitute for legal advice that you would get through a detailed consultation with an attorney. Again, please feel free to submit questions and we'll do our best to answer them. So with that, we'll advance to the first slide and talk about the Families First Coronavirus Relief Act. And as most of you should know by now, the primary thing that this did from an employment law perspective was create this new paid sick leave, basically 2 weeks of paid sick leave, and also extended emergency family leave for up to 12 weeks. Again, a brief review, up to 80 hours, 2 weeks of paid sick leave. If an individual is sick, or if they're told to quarantine, or if they are experiencing symptoms and out getting a medical diagnosis, or if they're caring for someone under the same circumstances. The extended emergency family leave applies to folks who have children with situations where schools or daycares have been closed, and thus they need to stay home to deal with caring for their children. Because many of you are not familiar with the Family and Medical Leave Act, and those requirements only apply to larger employers, many of you are smaller employers. This is a situation and an act that applies to employers with any number of employees, 500 or less. And it also applies in a situation where an employee has only worked for you for 30 days. Typically, under the Family and Medical Leave Act, an employee must work for 1 year and work at least 1,250 hours during that year in order to be entitled to the benefits of the Family and Medical Leave Act. This act is only going to stay in place. These two provisions, the emergency paid sick leave and the emergency family leave, will only stay in place until the end of this calendar year. And because they're paid, again, recall that the federal government is picking up the cost, if you will, of an employer having to provide the paid components of these leaves. And we'll talk about that in just a minute. Now, one of the questions that we've been getting quite a bit of is what type of certification or what type of documentation can I as an employer ask for if an employee of mine comes and says they need the paid sick or the emergency family leave. And the simple answer is that the certification is not like that and not as detailed as the one that you would as an employer get under the Family and Medical Leave Act standard provisions. You can ask for a signed statement that's going to verify the dates of the leave, the reasons for the leave, etc. But it is not and it's signed by the employee, not by a medical provider. So that it's a bit different than what you would see under the Family and Medical Leave Act. Now, another documentation issue that has come up with the Families First Coronavirus Relief Act is the small business exception for businesses that have fewer than 50 employees and who can say that allowing the family component of the leave, not the sick component, but the family component of the leave, would jeopardize their business, would jeopardize the financial viability of their business. They would have the right under the act to deny the request for leave. But in order to do that, the determination has to be documented, and the employer must be able to determine and document that the expenses associated with granting the leave would place a true financial burden and exceed the revenue that the employer would be expected to receive if the employee was allowed to take leave, or you would need to document that this employee is so specialized that allowing that employee to take leave would truly jeopardize the finances or operation of the business, or you would need to document that there are no other workers who are available to perform that same function. So again, a documentation, not a certification requirement, but a documentation requirement. And this documentation, either about the need for the leave or the financial hardship that you've determined would exist and jeopardize the financial viability of the business, that documentation needs to be maintained for 4 years. Now, the Department of Labor did not seek to enforce these provisions of the Family First Coronavirus Relief Act initially, when the act first went into place. There was effectively a 1-month moratorium on enforcement activity. That ended on December 17, and we have started to see complaints going to the United States Department of Labor about denials by employers when employees are requesting either the sick leave or the emergency family leave. And the Department of Labor has begun to investigate and respond to complaints of this type. So all employers now need to be aware of this and need to understand that requests like this have to be taken seriously and addressed, and employers must be aware of their legal obligations, at least for the balance of the year. One of the other questions we've been seeing quite a bit of is intermittent leave requests. Employers are being asked to allow employees to take leave on an intermittent basis. Now, what that means is, again, if you're not familiar with the Family and Medical Leave Act, intermittent leave is a standard part of that. What that means is employees are asking for the ability to take leave not on a full-time basis, meaning, for example, I need to take the next 2 weeks off. The employees might be asking, for example, to take their family leave every day between the hours of 8 and noon, or every day between the hours of 2 and 4, so that they can attend to the children that they need to care for. Remember that this provision, the provisions that are added through to the Family and Medical Leave Act have been added through the Families First Coronavirus Relief Act, are added on to Family and Medical Leave Act. And the Family and Medical Leave Act has always provided that intermittent leave can be requested and certainly can be allowed. It's something that an employer may be required to do, but there has to be a clear mutual understanding about the increments of time that the employees are going to take and the employer and the employee have to agree to it. Also, given the circumstances we're under, telework has to be taken into account. Many employees are teleworking, and so that needs to be taken into account as well when we are looking at whether an intermittent leave request is something that's reasonable and needs to be allowed. Also recognize that for employees who must report to work, there are going to be a different set of circumstances and rules that will apply to them. Now, tax keeping and tax credit and record keeping requirements. As I said at the outset, and as you probably know, the federal government is effectively paying for both forms of this leave, whether it is paid sick leave or the emergency family leave. The dollar amounts are capped, but the federal government is effectively paying that through allowing a tax credit. The tax credit is something that applies to all of the payroll taxes that an employer needs to pay. So effectively, provided that you have a sufficient payroll and are being required to withhold and pay over to the government a sufficient amount of tax withholdings, you can immediately deduct and not pay over to the government any paid sick leave or any emergency family leave that you have paid to an employee during that prior pay period. So you're collectively, as an employer, your tax withholdings are available to credit against what you're paying for either form of leave, okay? Now, I think we can jump on to the next slide. Thank you. So wage and hour questions, we've been getting a lot of these as well. As time has gone on, we've seen certainly reductions in hours. We've seen questions about reduction in salary and reductions in hourly wages. We have also seen quite a bit of uptick in activity about wage complaints. As you can imagine, employees who are working may not be happy about it. And so they may not express that unhappiness directly to an employer, but they may not be happy about the fact that they are needing to report to work. And think about the types of employees who are actually physically being required to go to work these days. They are concerned about increased exposure. They're not necessarily happy about being at work, and they are logging complaints. I've personally seen a few of them over the last week, and I know that, for example, in Massachusetts, the Attorney General's office is logging complaints and is continuing to do investigations into employers. Employers are certainly allowed to reduce, during this time, reduce hours, reduce employees' salaries, reduce hourly wages, obviously not below minimum wage, but you're allowed to do it. In general, though, in order to do it, it needs to be something that is done in advance. Certain states have notice requirements. For example, New Hampshire has a notice requirement and a requirement that if you're going to reduce an employee's salary or hourly wage, that be a notice that's acknowledged and signed by the employee. Certainly, you need to implement any reductions at least one pay cycle in advance. Many employers are looking at bonuses. They're looking at, for example, hazard pay. Bonuses and hazard pay certainly hazard pay if you're increasing the hourly wage of an employee or increasing an employee's salary to account for the fact that they are working under more stressful circumstances and perhaps running the potential for exposure. Those need to be factored into regular rate for purposes of calculating an employee's overtime. Some employers are providing stay bonuses. Bonuses also have to be included in the regular rate for overtime purposes if they are non-discretionary. As a general rule, discretionary bonuses do not need to be included for overtime purposes, but non-discretionary bonuses do. Reporting pay and remote work is a little bit of a challenge. Most states have a reporting pay requirement that talks about if an employee is required to report to work and does report to work, but if the employer then sends them home saying that there really isn't any work for you to do, there's a minimum. Whether it's a 2-hour minimum in New Hampshire, a 3-hour minimum in Massachusetts, there is a minimum. With remote work, that's obviously a bit different, a bit more of a challenge, but it sort of spells out the need to have very clear expectations about what work hours will be and how they will be logged by employees. Now, commission and bonus issues are also a challenge, always a challenge. But employers are certainly allowed to change commission and bonus plans on a prospective basis. I would say be extraordinarily careful if you're going to do that, because we often see employers get into trouble, and we often see disputes about bonuses. We often see disputes about commissions and whether employees are entitled to commissions. In times like this, any changes made will raise the eyebrow of the Department of Labor if a complaint is made. So I'm gonna turn this now over. We'll advance the slide, and I'll turn this over to Jim, who's going to start to talk to you about furloughs, layoffs, and workforce reductions. So Jim.
Good morning, all. Thanks, Mark. I think Mark did a great job on that. Some difficult issues for sure that we're all dealing with, and it's been a busy couple of months. If we have to project, it's going to be a busy few more months going forward with all sorts of issues. And that's the reason why we're doing this program, which is we're transitioning now from introducing the topics of Family First and the CARES Act and so on, and now getting into many of the questions we've been dealing with as this COVID situation has evolved and as we're looking to reopen workplaces. Liz Bailey and Karen have done work on this, Brian as well, and Karen and JP Harris are going to be doing part 2 of this next Friday, focusing on the actual return to work and what employers can and should do. In the meantime, as Mark said, we want to talk about furloughs, layoffs, and workforce reductions. Many employers out there, going back to March, started to go through the process of furloughs. Even before Family First was adopted, companies were going through the furlough process, reducing, shutting down the workplace, and or just reducing the number of workers there, suspending schedules and shifts and so on. There is a common misunderstanding between furloughs and layoffs. A furlough is usually a temporary suspension of work activity with a full anticipation that employees will be returning at some point. A layoff is usually a termination of employment. And that is what usually occurs. Now, sometimes there is what is called a temporary layoff. A temporary layoff is really a furlough. So there are important distinctions in that regard, but I wouldn't get necessarily hung up on those. But when communicating with employees, I think it's important to be clear what your expectations are, what their expectations are about potential return to work, or if you are in fact terminating their employment. So what are the benefit continuation options available during a furlough? Well, we know with a layoff or a termination, you go towards, if you're a covered employer, you go towards COBRA and the payouts. I'll talk about that in a second. But when on furlough, there's a suspension. So an employee may be receiving or using their PTO. The employer may not permit it for cost-saving measures. They may say, hold on to that for when you come back. Some employers have been paying during furlough. Most don't. What about health insurance benefits? The health insurance benefits are ones that are entirely up to the employer. The employer can do it based upon their plan. They can do it based upon conversations with the plan provider. Many plan providers recently have gone the route of saying, don't worry about COBRA during this period of time because of the period of time we're talking about, a month or so of the furlough, and said, just as long as the premiums are paid, either by the employer or by the employer and the employee, then coverage can continue because furloughed employees are deemed to continue to be considered to be employees of the employer. What if there is a situation where you have a furlough, but weeks down the road, determination is we don't need everyone back. We're now going to terminate employment. We can't recall everyone. Well, then it changes to a what could be construed as a layoff or termination. So what are the final pay requirements? Mark just talked about these a little bit with regard to pay issues under state law, and that's typically what you'd be looking at. While the Fair Labor Standards Act, the federal law, does talk about final pay, you focus on your state law requirements because they're more specific. In New Hampshire, we all know what that is. It's if there's a termination of employment, typically it's all wages due to the employee within 72 hours of the separation date, except when it is a layoff. If it is a layoff, it's the next regular pay day. So you've got some discretion in there. Now, the other thing you've got discretion on is what is included in final pay. If it is your policy or practice or both of paying accrued but unused paid leave time in separation, that's a part of the final paycheck. It's your policy or practice or both. That is not the case in Massachusetts. My understanding in Massachusetts is that is included as a part of the final pay, and the final pay is immediate upon the separation date. But remember, when we're talking about a furlough is not the termination of employment. Therefore, paid time off is not due. And just like there is no final pay because the person continues to be employed. We're seeing, as Mark said, we're starting to see the percolating up of claims, workplace claims of some sort, or threatened claims. Why was I selected for the furlough? Why was my pay reduced? How is it I've now been selected to be terminated as a part of a group, as a part of a larger layoff? And are there discrimination issues that could be coming up? Certainly, and we do expect that those will come along. So if you are going down the route of terminating employees and providing some form of a severance benefit, and with that, a general release, of course, the first thing we would recommend is you have your legal counsel prepare it, and competent legal counsel that deals with matters like this all the time. You would also, it depends upon the size of the employer. If you're a private sector employer with 20 or more employees, you're covered by federal age discrimination statutes as well as other statutes as well, under state and federal law. Based upon that and the size of your workplace and the size of the termination group, rather, you may have a situation where you're covered by the Older Worker Benefit Protection Act, meaning that if you have terminated employees who are over age 40 and you're asking them to sign a release, then that release includes age discrimination claims, then you have to follow the very specific and precise requirements of the Older Worker Benefit Protection Act. And very quickly, 45 days to consider, 7 days to revoke the acceptance, clear that they're releasing age claims, the opportunity to check with legal counsel, and most importantly, or of equal importance, a census of those that are part of the RIF and not. Again, very specific requirements. We deal with these all the time, but if you do not have a proper age release, you could pay out severance and someone could still sue you or advance a claim for age discrimination. So be careful and consult with legal counsel on that. So what happens if your furlough goes beyond the period of time that you expect? Many furloughs out there are between 6, 8, and 12 weeks. Pretty long period of time. But what happens if you think, gosh, the business has not recovered to a point and we need to terminate and now move from a furlough to a layoff, or worse yet, a plant closing altogether? Well, then you may have a situation, if it's a plant closing, you may have a situation under WARN, the Worker Adjustment Notification Act, or the Mini WARN Act, your state statute. In that regard, what's required? If you're a covered employer, 100 or more employees, and you've got the requisite number of either it's a plant closing or a mass layoff. Mass layoffs are defined by the state statutes. In New Hampshire, it is 1/3 of the workforce representing at least 25 employees who suffer an employment loss. Under the Federal WARN Act, it's 1/3 of the workforce, at least 50 employees that suffer an employment loss, within a defined period of time, but it has to be for at least 6 months. So if you've got a furlough that extends beyond 6 months, the question is, okay, then, or it's expected to last beyond 6 months, what are we supposed to do? Well, the WARN Act and the Mini WARN Act require notification to the employees, potentially if there's a union involved, to local officials, to state officials, and so on. Is there an exception under WARN and Mini WARN when you have a pandemic? No specific requirement, no specific reference rather to pandemics. However, there are emergency exceptions to WARN in an unanticipated and dramatic business circumstance that is not reasonably foreseeable. That would be an exception to the notice requirement. What does that mean? As soon as you expect there to be a layoff, you can shorten the notice period as to when it is reasonably anticipated that you are going to be now terminating employees. So that is, again, something to check with your legal counsel on as to whether or not you've got a WARN situation. And then finally, and next slide, we're dealing with unemployment issues. I'm just waiting for that next slide to pop up. Thank you. The receipt of unemployment benefits, and we know that that's been a bit complicated by the CARES Act. You've got your state unemployment benefits, but as a part of the CARES Act, eligible employees also receive $600 a week. If you receive even $1 of unemployment benefits under state law, you can still get the $600 under the CARES Act until the end of July. So questions that come up and have been coming up are can an employee receive, who's on furlough, receive unemployment benefits? Generally, yes, because again, it's a suspension of work activities, a reduction in compensation, a reduction in hours. And so can they receive those unemployment benefits? Yes. And it's the state is the one that doles out the money, both from the state and also from the feds under the CARES Act. So you have to meet the qualifications of the state. But yes, with regard to if a furloughed or terminated employee receives paid time off, can that have an impact upon unemployment benefits? Well, it depends upon the state you're in. The answer is in New Hampshire, if you're receiving paid time off as a terminated employee under any circumstances, that will delay when you receive a severance benefit. Any payments at the end of employment are considered to be potentially an offset against unemployment benefits for as long as they continue. That is not necessarily the case in Massachusetts. And so the question is, what impact does it have when someone receives PTO if they're just on a furlough, they haven't been terminated? Again, it depends upon the state. In New Hampshire, technically, if they're using PTO or receiving PTO during a furlough, it should delay unemployment benefits. But what we're finding is that state unemployment offices are absolutely overwhelmed by these claims. And so you'll see a lot of things pass through that perhaps otherwise wouldn't have been approved. Can an employee, we're seeing a lot of this, can an employee receive unemployment benefits if he or she is afraid to return to work? Sound familiar? And the answer is, generally speaking, most states define the eligibility for unemployment benefits as if the person is out of work through no fault of their own. Now, someone could claim, it's not my fault, I have an underlying health condition, or I don't think my employer has a safe workplace, and so on, so I don't think I should go. Those have been passing through, but technically, it's not enough to qualify for unemployment benefits. And then return to work requests. We're starting to see more of these when employers are saying, we've got work available, we've reopened, we've got the Paycheck Protection Program, we've got payroll, we'd like you to come back to work. And the employee says that he or she doesn't want to come back to work yet. Work available should be a disqualifier. And that is something you can certainly challenge with your local unemployment office. With regard to employees that come back to work but don't follow the employer's safety policies, meaning specifically whether it's social distancing or wearing a mask or wearing gloves, can you terminate the employee and with that challenge that person's unemployment benefits? I mean, the answer is technically yes. It's like any other policy. If you make it clear to the employees that these are our requirements, and the person fails to follow that, and they understand that failure to follow that could result in the termination of their employment, technically, certainly under New Hampshire law, they could lose their unemployment benefit. If they lose their unemployment benefit under state law, they will lose the unemployment benefit under the CARES Act. Certainly a lot to consider in a 30-minute webinar, and that's why we have a part 2 coming up next Friday. We have a minute or two for other questions.
Jim, we've seen a few questions come in. Let's try to address a few of them. I don't think we'll be able to get to all of them because there are quite a number. But let's start with the first question, which is, how is the New Hampshire Department of Labor handling the 2-hour minimum pay requirement if someone arrives at work with COVID symptoms and you need to send them home? Is it being waived? Is that 2-hour minimum being waived? I'm not sure we've seen that one yet, but maybe you know the answer to it, Jim.
Yeah, there's under our state law, even before the COVID crisis, there's the 2-hour minimum, and meaning if the employee reports to work, not remote work, but reports to the workplace at the employer's request, and the employer doesn't have work for them, you send the person home, you have to pay a minimum of 2 hours. One of the exceptions to the 2-hour minimum has been if the employee leaves work because of either the employee's illness or a family emergency, then you can, it's a shortened period of time and the 2-hour rule does not apply. I would believe that most employers would still probably default to the 2-hour pay.
Okay, here's an interesting question. Our company policy states that an employee must self-quarantine for 14 days if they travel to a hotspot state. So if an employee travels and under our company policy must quarantine, are they eligible for the Families First Coronavirus Relief Act leave? And I would say to you that the answer is technically no. The act does not provide for leave under those circumstances, but I would look closely at whatever other policies might be in place, whether it be paid time off policies, vacation policies, etc. But technically the act would not cover a leave, which is essentially voluntary in a matter of company policy for quarantining when there's not some other reason to do that.
Yeah, if you're not quarantined by a directive of either a physician seeking diagnosis or directed by a state or federal official to quarantine, I would agree the company policy doesn't necessarily qualify under the Family First Act.
Okay, I think we've got time for 1 or 2 more here before we end it. We're trying to respect people's time and keep this as close to a half an hour as we can. Here's one on intermittent leave. For an intermittent leave request, can an employer deny the request if it is a hardship? I guess I spoke about that, so I'm going to take that question. Hardship is not a reason for denying generally any kind of FMLA leave request. Now, when we're looking at an intermittent request, we want to consider whether this is an employee who must report to work or an employee who can telework. An employee who's generally asking to take the intermittent leave under the Families First Act is only, first of all, going to be allowed to do it if it's needed to care for or they're actually caring for a child whose school or daycare is closed. If you're talking about an employee who has to work on site and needs leave for other coronavirus reasons, meaning self-quarantining or caring for someone with symptoms, then intermittent leave is not going to be allowed, but full-time leave will be allowed under those circumstances. Let's see. Here's one that haven't seen before. Under the Family First Coronavirus Leave Act, if the wage rate for the 2/3 pay, and remember that the pay is not for the family leave component anyway, is not full pay, it's 2/3 of the employee's pay. If that pay at 2/3 the rate is lower than the state minimum wage, which rate is paid? Is it the minimum wage rate or that 2/3 pay rate? Jim, I'll grab that question because I did have a chance to look at it last week. And the guidance from the Department of Labor and the regulations that have come out say that minimum wage, at least minimum wage, has to be paid. So if you have an employee, for example, who is working at the minimum wage rate and needs to take the leave, and they would otherwise receive 2/3 of that wage rate, meaning 2/3 of minimum wage, you do have to pay at the minimum wage rate. I think that's about it for questions. That's about all the time that we have. I want to thank you all for attending today, and also remind you that next Friday, part 2 of this series is going to be presented by Karen Whitley and JP Harris. Also next week on Wednesday, our healthcare group is going to be presenting a webinar on topics that are unique to those of you in the healthcare world. Until we see you next time, we want to wish you all well, ask that you stay happy, healthy, and safe during these difficult times, and we will see you soon in person, hopefully. Thanks.
Thanks, folks.